Welcome everyone, those of you here present in our Court 4.1, and also to those of you joining us online by AVL. Can I begin by acknowledging the traditional owners of the land on which we meet today, the Gadigal people of Warranay or Sydney Cove, and pay respects to their elders past, present and emerging, and to their legacy. Tonight we are, as advertised, going back to basics. So we are talking especially to those of you who are less experienced practitioners, industrial officers, HR, personnel, and solicitors who perhaps have not or are not experienced in appearing in tribunals generally, or in our commission specifically, particularly over the wage cap era, if I can describe it in that way. And so, with apologies to those of you who are, I know there's some of you who are quite experienced practitioners, bear with us for really going back to some fundamentals this evening. So the plan is, I'll start off by giving you a little bit of a rundown about who we are and what we do. I'll then talk about your role as advocates who appear before us, with some basic tips about how to interact with us. And then I should introduce my co-speaker, Commissioner Webster, who I will throw over to address you on what we really want to focus on, which is perhaps the main way in which you'll be coming before us, at least with respect to industrial disputes, and that is in conciliation proceedings. I'll pick it up and touch on arbitration matters a little bit, and then back to Commissioner Webster on the impact of our new practice note on generative AI, and to wrap up, after which we hope to have some time for questions. So over to the next, the first slide, please. That's a photograph of a witness leaving the Industrial Court in New South Wales, Industrial Arbitration Court, in 1936 in a living wage case. But of course, we're much older than that. In fact, we are the oldest, I think probably the oldest continuing tribunal or court of compulsory conciliation and arbitration of industrial disputes in the world. Our first sitting was on 16 May 1902. And a little known fact, the famous decision of Justice Higgins in the Harvester judgment in 1907, which enshrined nationally the concept of a living wage, came 2 years after the first case in the New South Wales Industrial Arbitration Court, which conceived of the notion of the living wage in this institution. It was an arbitrated decision to adopt such a wage for sawmillers in 1905. So we're old. And since July last year, we are whole again, in the sense that the Industrial Court of New South Wales was re-established. Over the next slide. Perhaps for our AVL participants, could we, Robert, enlarge the slide a little bit? So since 2006, the work choices legislation, the industrial jurisdiction, our industrial jurisdiction has largely been confined to the state and public sector and local government areas. We have waxed and waned with jurisdiction somewhat, but with the re-establishment of the Industrial Court, as I mentioned, in July 2024, the Commission, when sitting in court session, is known as the Industrial Court of New South Wales. So we are the one body, but the judicial members of the Commission can wear two hats, that is a tribunal member as President, Vice President and Deputy President, and also as judges of the Commission when it sits in court session exercising judicial power. So we're made up of the President, Justice Ingmar Taylor, myself, The Deputy President, Justice Jane Panacalam, who's here with us today. 5 commissioners, including Senior Commissioner Nicola Constant and my co-speaker, Commissioner Webster. We've also been recently blessed with the appointments of 3 acting justices. Acting Justice Peter Kite, formerly Chief Commissioner of the Industrial Relations Commission. Acting Justice Monica Schmidt, Judge of the former Industrial Court of New South Wales and Deputy President of the Commission. And indeed, as I understand, the longest serving judicial officer in the state. And Acting Justice Robert Hume, who is a leading criminal law expert who has sat in the New South Wales Court of Criminal Appeal. So a lot of experience there for the Commission. And if I just run through some of the main highlights of the amendments that came through last year, the court principally has jurisdiction now over the enforcement of industrial instruments, awards and agreements, offences against industrial legislation such as contravention of dispute orders, unfair contracts, and of course criminal prosecutions under the work health and safety legislation. We also hear appeals, and we are generally the Court of Final Appeal, subject to judicial review, oversight of the Court of Appeal of New South Wales, and also with a provision for appeal to the Court of Criminal Appeal against convictions under the Work Health and Safety Act. Of course, at the same time, or roughly the same time, the wages cap was removed so that the wages cap no longer constrains the powers, the arbitral powers of the Commission in making awards and setting fair and reasonable terms and conditions of employment. We have introduced a mutual gains bargaining framework as a prelude for parties into either hopefully productive, mutually beneficial agreements, or if necessary conciliation, the traditional conciliation and arbitration services of the Commission. We have new statutory duties in terms of taking into account the government's fiscal position and outlook, and also objects which are new, which include having regard to strategies to attract and retain skilled staff where there are staff shortages. We also have a federal underpayments jurisdiction. We are the Industrial Court. On one view, even though since 2016 we were not in existence in New South Wales, the Fair Work Act kept the faith in the sense of maintaining a reference to the Industrial Court of New South Wales as an eligible state or territory court within which certain enforcement or compensation proceedings can be, or recovery of wages proceedings could be taken under the Fair Work Act. But if there were any doubt about that, then the Fair Work Regulations, 2009 Regulation 105A, has been amended to make it explicit that we are an eligible state or territory court for that purpose. So that's a rough overview of what we do. There are jurisdictions under the Police Act for police discipline and removal matters, work health and safety, external review of safe work decisions. This is the Commission work, not the court, and a number of other areas like public sector disciplinary appeals. So we are busy, and we are going to get busier. I'm not even going to address on what might be on the horizon, but that's just a general introduction. Over to the next slide. One of the first steps we took as the presidential members were appointed last year was to initiate a thoroughgoing review of our wage fixing principles, which had been around for about, in various forms, for the best part of 30, 40 years. If I can, I don't want to pitch it as required reading, but perhaps recommended reading for those of you who are going to appear here and to invoke our arbitral powers in wage cases, I think it pays to have a look at what the extended full bench, 5-member bench of the Commission has said and done in reviewing its guidelines, as it were, that constrain or guide the exercise of our discretion in making awards and setting terms that are fair and reasonable. In the 2 state wage case decisions that I've got up on the slide, among other things, we've introduced a wage fixing or award making principle that addresses wage increases for rises in cost of living for the first time. We've also reframed the nature of the onus or the burden carried by any party that's seeking to vary or make new awards. So I think it's a significant development that will be hopefully a lasting legacy for how we operate going forward, and I recommend those decisions to you. The next slide. I want to now just go to a few matters about having regard to who we are and what we do, how you might best interact with us as advocates and participants in the process. I promised the President that this would not be a section all about my personal pet peeves, but he's not here, and I don't think he's participating online, is he, Georgia? Although I did see his associate, so I better be careful what I say. It won't devolve into that at all, but I wanted to make the point that we are set apart from other jurisdictions. We are specialised. We have expertise in industrial matters, but we have a statutory mandate to function according to the substantial merits of the case and not to get bound up by legal technicalities. Accordingly, we in some ways adopt a less formal approach, especially in conciliation proceedings, but that is not to say that we are completely informal. So I wanted to make that point. And it really is about us being user-friendly, but that not being an invitation to parties to regard the Commission as some form of help desk from Service New South Wales. All due respect to help desks at Service New South Wales who perform a vital function. But that's not the type of institution we are. We are a tribunal and a court of superior record, equivalent in status to the Supreme Court of New South Wales. And it's important to interact with us with that in mind, and to observe some basic standards. Now, I'm going to be devolving into some fundamentals here, so those of you more experienced will probably be able to switch off. But some do's and don'ts. Do stand and bow when the judge or commissioner enters the room. Do bow to the crest behind me when entering the courtroom and when there is a judicial officer or commissioner sitting on the bench. Doesn't need to be elaborate, just a small bow. When you're speaking on the record to the bench and you're standing at the bench and you're at the bench, stand when you speak. Learn who you are appearing before so you know how to address the officer. If it's a commissioner, then address the person as commissioner. If it's a judge, then address the person as Your Honour. If it's a registrar, then use the registrar's title. If the answer to the question asked by a judge is yes, say yes, Your Honour, or yes, Commissioner, not yep. Do leave a positive review in Google Reviews after you leave. That last one's optional, granted. I had a look before coming on the bench. We have a paltry 1.5 stars rating for the Commission, but but curiously a 5-star rating for the Industrial Court, based only on one review. But anyway, that last one's optional. Now, don't email to relist your matters or list your matters before the Court or Commission, assuming that the Court or Commission will do what you ask to suit your schedule. Don't send in material late without seeking or acknowledging that orders have been breached. In fact, I'll come to this later, but you really need to apply to vary orders before you contravene them. It's very important. Don't be overly informal in email correspondence. For instance, real-world example, do not sign off on correspondence to the registrar using a double X or emojis. Don't treat the registry like your paralegal. Don't ask them to get data for you or information about previous matters. That's not their job. Don't post misleading Facebook posts about Industrial Relations Commission decisions that risk inflaming or prolonging industrial disputes, although that last one is subject to a full-bench appeal. If you know, you know. And next is, I think, next slide, is some of the basis for why those behaviours should be observed. The first point I want to make is that you need to be aware the Civil Procedure Act, parts of it, and this part in particular, applies to commission proceedings and court proceedings. So the overriding purpose that the Commission is bound to serve, namely the just, quick and cheap resolution of the real issues in proceedings, applies to the Commission. And in section 56(3), the parties you represent have a statutory duty to assist the Commission in achieving this purpose, including by complying with its directions. And the next slide, non-compliance can amount to a contempt of the Commission, and a contempt of the Commission is an offence. So that's a statutory context, part of it, in which you need to be conscious and aware when you're interacting with the Commission, dealing with the Commission, appearing before the Commission. And having regard to that, I can go to the next slide, and maybe perhaps if we enlarge this, Robert, for the participants by AVL. Again, in terms of compliance with directions, what you should be doing is, as I said before, ask the Commission to vary orders before you breach them. Now, you are not always going to be able to comply with orders. We understand that. Exigencies arise, a whole litany of reasons. But the way to do it is you first seek the consent of the other side, your opponent, for the variation. Never communicate with the Commission, the registry, commissioners, judges, without the consent of the other side, or if you can't get the consent, at least without copying the other side into the correspondence. It's not appropriate to unilaterally communicate to the Commission in proceedings without the other side's knowledge. You apply to vary orders as soon as you become aware that you can't comply with the direction, you ask the Commission to vacate listings of matters if you need to, if there's no longer any need for it, knowing that unless and until the Commission informs you that the listing has been vacated, then you are nonetheless required to attend. Don't write to the Commission simply telling the Commissioner or a judge that you won't be able to file on time. That's very interesting, but it doesn't get you very far. Don't simply write to the Commission or the judge and tell them that you won't be appearing at tomorrow's listing because the matter's just been settled. You're required to attend, unless it's been vacated. You make the request. Don't assume that the Commission will vary directions or vacate the hearing date, whatever you've asked, just because you've asked. You can't assume that. You can lose consent applications if the overriding purpose calls for it, because the Commission has a statutory obligation that overrides your convenience and indeed its convenience. You apply, the Commission decides. Before I hand over to the Commissioner, I just want to, I don't want to over-egg this point, but having regard to that statutory context, even if you're not legal practitioners, there is an overriding duty to the Commission to assist the Commission, and the manifestations of that duty can take the form of specific obligations in specific circumstances, namely not to mislead the Commission, not to mislead your opponent, and it may extend to circumstances in which you might have a duty to disclose errors that are made, errors that your opponent makes that might be helpful to your case, but which you know to be wrong as a matter of law or fact. And in addition to that, aside from your technical or strict duties, let me just leave you for this part with this thought. Legal obligations aside, your main currency as advocates in this place and in all courts and tribunals for that matter is your credibility, your reliability, your trustworthiness. It is the trust that a decision maker has in your advocacy on matters of fact and law that is precious and fragile. It's hard-earned, easily lost. To quote or adapt the words of Thomas Paine, once gained, it's much easier kept than recovered. Never knowingly mislead the Commission. If there's inadvertent misstatements of fact of law, correct them immediately when you realise the error. If you know your opponent has made an error, that if left uncorrected may be, although helpful to your case, nevertheless, don't hesitate to correct the error. Win your case fair and square. And with that, I'm going to invite the Commissioner to come up to talk to you a little bit about the process of conciliation, which is probably a lot of what we do.
Thank you.
Thanks.
I was just going to start off with a little of what Justice Chin's already touched upon, and it's about being respectful to everyone in the process. So I think that's a really important starting point. So as already indicated, it's important to call people by their surnames. That includes witnesses as well throughout the process. One of the things that I noticed is that sometimes, particularly in conciliations, parties will start talking to each other when we're on the record across the bar table. And that's something that we can do once we're off the record, but when we're on the record, it's all through me. So you can ask a question of your opponent, but you do it through the Commission. It's important, just again, the real fundamentals, not interrupting or raising your voice during conciliations. It does happen. And my all-time favourite, no sledging at the bar table. We've got good microphones. Sometimes we can hear the big eye rolls, the scoffing, the turning back and sniggering at those that are instructing you. It's not a good look, and it should be avoided. All of this, as I said, is just a sub-principle of the overarching idea of being respectful to everyone in the process. That includes, as Justice Chin's already indicated, thinking about our staff, the registry staff as well. If you haven't already guessed it, I can assure you that when someone's rude to someone in the registry, we all find out about it. So, it comes back. Another thing I just wanted to talk about is this concept that I've been thinking about in terms of kind of listening to people's language when we're in conciliations. So some of you might have heard of the concept of the four horsemen. It originates from the book of Revelations, the New Testament, and it was to symbolise the end of time. So 4 things: conquest, war, famine and death. I know what you're thinking, where's this headed? But psychologists took this concept, because it's quite a powerful analogy, and they've adapted it, particularly Dr. John Gottman, to a metaphor to describe 4 destructive communication techniques. And I've read that they can predict, psychologists can predict with a very high level of accuracy that a relationship is coming to an end when this is the kind of behaviour and language that they can hear when couples are interacting. Can I tell you that I hear those 4: criticism, contempt, defensiveness and stonewalling, those 4 same behaviours and language being used from time to time in conciliations. So what does it look like? I don't trust the management or union anymore. They lie to us all the time. Criticism, contempt. They're always obstructionists. They have no interest in working constructively with us. Defensiveness. We didn't respond to their requests because the information they gave us made no sense and it was given to us late. We're always being given information at the last minute and we don't have the resources to meet their deadlines. Stonewalling. Commissioner, if they're not going to come to the party with a better offer, we're leaving. We're going to up stumps today and finish up. So I guess the point that I wanted to make is that industrial relations practitioners, your relationships are really transactional. There might be an issue today, but it'll be replaced with another tomorrow and the parties are still the same. So I would suggest trying to avoid listening for that language of the 4 horsemen in the way that you speak about your opponent's a good starting point, and to contemplate that in your interactions when you're before the Commission. Because really what we're trying to do is push the parties away from that and towards mutual gains bargaining, which is where, you know, the language is more about what your common interests are and what the common mutual gains are that you can attain through the processes that we can offer. Enough about that. Conciliations. So I've seen a lot of familiar faces in here. May I ask, put your hand up if you've had a conciliation before me? Who's the people? So I pray that what I'm about to say kind of resembles what happens when you're before me. I think the main thing I would ask of advocates when they come to a conciliation to make sure you're prepared. And so importantly, you need to know the facts of your case and you need to be absolutely across the brief that you have in front of you. So preparation, as they say by the Scouts say, need to be prepared at all times, and I've never heard an advocate say that they wish they had prepared less. When you're preparing for a conciliation, I think that you can usually expect, certainly with me, I'll have read all the material before I come on the bench. I do worry sometimes I sound a little bit impatient, so I've read all the material. I think from the perspective of someone sitting on the bench, probably don't want to hear an advocate come in and just read effectively that which is already in the application and reply. It's your opportunity to shine. Prepare your elevator speech, hit those really important points, and really get to the nuts and bolts of what the matter is about. A lot of people in conciliations will, at the end, I'll ask the question, I'll have to ask the question, well, what is it that you want? You know, why are you here? Or what does success look like today? What outcome are you hoping to achieve? Have you come here today able to compromise on that position you've just put forward? So sometimes it's important to think about those things, but it's also helpful for me to know what I've got to work with after you've put your position formally on the record. There's lots you can read about process of negotiations, and there's one by, there's a lot of material that talks about preparing by thinking about the best and worst case scenarios. So it's important that coming into a conciliation you have thought about that as well. So if I don't get what I am able to achieve today through a conciliated or a negotiated settlement, then where do I go after that? And that you've spoken to your client about that so they know what the real risks are. I've already talked to you about rehearsing and making sure that the elevator pitch, that you're prepared for that, you're able to put your case in a clear, articulate way. I once heard that every advocate should be able to explain their client's case in less than 30 seconds. It might take you a bit longer than that, but if you've got that in your mind, then you're probably in a good position to articulate the main issues. Definitely there are cases where people come in. I've had plenty of matters where I've asked someone to tell me what the case is about and literally have been unable, so I wasn't prepared for that. I've equally had people come in and I've asked them to tell me what their case is about. I've read the material and their presentation has swayed me in terms of my thinking about the matter as well. One thing that's really important, particularly in the context of both unfair dismissals and public sector disciplinary matters, which is often overlooked, is explaining and giving context to the Commission, of course, about whether or not they want reinstatement or not, in the context of unfair dismissal at least, but also where they're at now. So I'll invariably ask people, have they got another job? And have they been looking? So it's really important to address that, I think, in your opening statements as well. If we can move to the next slide, I realise, thank you for keeping up and working out what I'm doing. In terms of negotiations, look, I'm not a big fan of the ambit claim, where, and that's what this represents, a fish is this big. I come here, I want 26 weeks. In the context of unfair dismissal, for example, or that kind of positional starting point that parties come in with. It's particularly annoying when people do that and they wouldn't be entitled to it even if they were successful. So an example would be where someone's on workers' compensation leave, so they've actually been receiving remuneration anyway, or they've received, 8 weeks payment in lieu at the end of their employment. So one wouldn't expect 26 weeks in those circumstances. So it's helpful, I think, just as a show of good faith, not to start at the absolute minimum and the absolute maximum. And sometimes I see that from employers as well. So we'll move to the next slide. So your role in coming to the Commission and conciliation, it's about being an advocate for the Commission and for me to be able to then work with you and persuade. Those of you who've had conciliations with me would know I'd often ask people, what can you give me to work with? My role and my job is to try and avoid arbitration and do whatever I can. So the more that you can work with me and give me to work with, the better and the harder I'll work for each of you as well. So you need to convince me, but often it's actually your own clients and the people that instruct you that you need to work on. And sometimes you've got to give them the bad news and be honest and say, look, I don't think this matter's going to fly. If we were to proceed, you're unlikely to succeed, and that can be hard, particularly when you're working in-house, because the nature of the relationships that people have when they're advising those that they work with day in and day out. One of the things I just wanted to emphasise today, and something that I think the Commission is doing increasingly, is the use of recommendations. So I issue recommendations quite regularly, not only in respect of dispute matters, but increasingly in other matters as well, like unfair dismissals. And what I've found with the recommendations is that often they help me to persuade the parties. I find that they're stuck and they say, well, look, What about somewhere halfway in between? I can't get either of you to move today, so that's what I'm going to recommend because I think it's fair and reasonable for both. That's quite handy and can often work. Sometimes I've found that recommendations are useful for those that aren't in the room. So a recent example of this was where I was assisting in conciliation in respect of an underpayment matter relating to a large number of employees represented by a union and those employees obviously weren't able to be in the room. But I was able to make a recommendation that would be available for that audience to read and to understand, which potentially will assist all of the parties, including the union itself, for them to understand the basis upon which they might want to proceed as well. And sometimes in the background lurking might be someone difficult within the management line, just saying, from time to time, and that can be helpful as well in terms of getting across why a particular course of action might be taken. So keep that in mind. Always, open to hearing about why I should make a recommendation. My practice is usually to tell the parties that I'm thinking about doing that and hear from you about whether or not I should do that as well before proceeding. We can move to the next slide. Obviously there's an analogy coming here. It's about seeing the forest through the trees. So when preparing your case, so don't forget to see that forest through the trees. Sometimes less is more, and just question whether or not it's worthwhile taking every point in every matter rather than just focusing on those aspects where you're likely to be more successful. So quickly concede the points that you should as well, and this will get you, as I think Justice Chin referred to, greater credibility with the bench as well if you're honest and open and quick to see where you're losing and you should just move on. And now I'm going to hand back to Justice Chin to talk about the journey towards arbitration.
Yes, thank you. So we've been through conciliation. A certificate of attempted conciliation has been requested and issued by the Commission, and the matter is not resolved despite Commissioner Webster's sage recommendation. And so the parties are off to arbitration. That's the next step. I just want to touch on two broad matters. Question of relief and the question of evidence, admissibility and form. If I can leave you with those two thoughts, we'll go to the next slide this afternoon. Perhaps, Robert, if we can enlarge that for our AVL participants. If you haven't already thought about what relief you are seeking from the Commission, which you ought to have in conciliation, then in arbitration it becomes critical. What I want to emphasise now is that you have more options in the new configuration of the Industrial Relations Commission sitting as a commission and sitting as the Commission in court session. So let's say you have a dispute about the application of an award provision and there is a disagreement about its effect, meaning. You have the option of proceeding in the Commission to vary the award or make a new award to resolve the dispute by inserting a new provision or varying the provision that is in dispute. Or you can seek a binding declaration of right from the Industrial Relations Commission sitting in court session as an alternative, namely that you are so confident in the in your interpretation, construction of the provision, award provision in dispute, that what you would seek is a declaration which is binding, legally binding on the parties from the Commission in court session as to the effect and meaning application of the award provision in question. And you can do so where the Commission's constituted by a presidential member and without going to another court or another institution because the presidential members effectively can wear two hats, or at least take one hat off and put another on in proceedings in this commission. You'll also give consideration to the other available relief, whatever you're seeking, a dispute order, be it a binding dispute order, if there's industrial action taking place, or indeed a recommendation as is available in conciliation, but also not just a recommendation, but a binding direction of a procedural nature. So it's important to formulate what relief you want before you embark on arbitration, because that's going to guide what your case is going to be, and you'll need to marshal your evidence. Now, in arbitration, unlike in conciliation, everything is on the record. And when I say everything is on the record, everything is recorded in transcript. And in order to submit evidence to the Commission for the Commission to take into account, it needs to be tendered as evidence. You don't do that by handing up copies of your documents before the judge or the Commissioner comes on to the court officer and say, can you give this to the judge? You have to do it on the record, recorded by transcript, so that everyone can see publicly what is happening and it's recorded. And where witness statements are concerned, in other courts, the practice would be to read the witness statement or the affidavit into evidence, not actually read the whole document, but to say, I read the affidavit of John so-and-so or Jane so-and-so, and get it in evidence that way. The custom and practice in this institution is to mark statements as exhibits tendered in the proceedings. So you will say, I want you to tender this statement, and the Commission will, subject to objections, mark it as Exhibit A or Exhibit 1. Once that's done, that is evidence, and that is something the Commission can take into account in coming to its decision on your case. As to evidence, returning to my initial remarks about the relative informality of the Commission, the Commission itself, not in court session, but sitting as the Commission simpliciter, is not bound by the rules of evidence. That is not to say that the rules of evidence play no role in Commission proceedings. You will see that most objections to evidence in the Commission in practice will be dealt with by the Commission admitting the evidence, quote, subject to weight. We don't want to, when sitting in the Commission, we generally don't want to get bogged down by tedious technical objections, and so we'll be inclined to admit evidence subject to weight. Now, returning to my theme about the applicability or the use of rules of evidence, it matters in this sense that if your evidence is in such a state that it would never be admitted under the rules of evidence because it's third-hand hearsay on a critical point in the proceedings in a form that is just basically an opinion, then you might have got the admission part, but the subject to weight part doesn't really help you because there may be very little weight placed on the evidence that you've tendered. So it does, can I exhort you to pay to have regard to doing your best to knock your evidence that you rely on into shape that is admissible or very close to it, because the rules of evidence are designed basically to ensure that evidence given by witnesses is reliable and likely to be truthful and reliable for the court to rely on. So the closer you can cleave to those conventions and those rules, the better for your case, even though, strictly speaking, those rules do not apply, and for very good reason, in the Commission. This leads me to the preparation of your witness statements in arbitration, and this I want to touch on before I finish up, on a recent controversy amongst the courts about what the proper form of witness statements, affidavits should be when someone's giving evidence about what someone else said. Now, I know I've probably breached all the rules about effective slides with this slide, and I've insisted on including it despite the Commissioner's objections. I don't expect you to read it now. I've really put it in because you're going to have access to the slides, and I want you to take it away and you can look at it. But I've included this paragraph because there's been, as you would know, a controversy about whether it's permissible for someone in a witness statement to say something to the effect of, person A said to me, words to the effect that, quote in inverted commas, the direct speech. Now, there are some judges, particular judges on the federal court, who think that is not right, impermissible, indeed actively misleading. And a difference in view has emerged between judges in different courts about the suitability of that form of evidence. I include this quote because in the case of Wild and Maduri last year, at least in New South Wales, the position seems to be captured by what was said by Justice Kirk of the Court of Appeal, with whom the Chief Justice agreed in this case at paragraph 356. So the prevailing position in New South Wales appears to be that so you can say something like, person A said to me, words to the effect that, inverted commas, we have a binding agreement for the next 5 years or whatever, close inverted commas. And you can say that if the person doesn't have an exact recollection of the words that are being quoted in direct speech, then you should make clear that what's being said is words, the gist or the substance or the effect of which was what's quoted in your direct speech. So make that very clear. Unless the person can in fact remember the exact words that you are putting in quotation marks, in which case do that. Pretty rare, but if that is what the witness is telling you, person A said to me, yes, I will, close inverted commas, and has a direct recollection of the exact words used, then that's legitimate. But if it's the gist or the effect or the substance of what was said, then you need to make that explicit, that what you are quoting is not purporting to be the exact words of the witness's recollection. Because as Justice Kirk says, the aim should be to capture the best recollection of the witness with the level of detail appropriate and relevant for the issue in the case. Doing so in a way that is not misleading with respect to the level of detail that the witness remembers. So that's an approach that I urge everyone to take in arbitration proceedings in the Commission. Now, relevant also to the preparation of witness statements, may I segue, is our new practice note on generative AI, which adopts the Supreme Court practice note, about which Commissioner Webster will now address you in wrapping up.
So there is a new practice note on the use of generative AI in the Commission, and it's in place now. Commenced on the 19th of February and applies to all proceedings from that date. Importantly, it applies in the court and the Commission. So irrespective of where you are, you need to understand the practice note, particularly if you're like me and you like generative AI. And you've started to adopt it. So in terms of what is described as AI, can I actually just start with a show of hands? Is anyone aware of this practice note? Most people are. Well, that's good to know. So generative AI is capable of creating new content, so text, images, sounds based on patterns from training data. It's things like ChatGPT and a whole host of other platforms as well, some of which are actually quite specific tools to the legal world as well, like Legal Advanced AI, ChatGPT for Law, Westlaw Precision, and so on. So if you're using any of those in your practice, then you need to be aware of this. The practice note is largely based upon, with a few tweaks, it's basically the same as that which was recently released in the context of the Supreme Court of New South Wales. So I think what's important to understand is that it's not a prohibition. There are permitted uses for generative AI in the work that you do before the Commission. So you can continue and use it in tasks such as drafting documents, summarising information, generating chronologies. I can say that it's very handy for that purpose. Witness lists, preparing briefs and summarising documents and transcripts. It's not on this slide, but it can also be used for submissions. But there are some important caveats around that, which I'll turn to shortly. It cannot be used in the context of generating content for affidavits, witness statements, character references, or any material intended to reflect a witness evidence or opinion. And if you are in the space of having expert evidence, there's specific provisions in respect of its use within that context as well. I'm thinking that most people are well aware by now that there are a lot of risks with using it even within those contexts, hallucinations, data quality and confidentiality. So I think the most important thing in this short period of time I wanted to emphasise is that where you are able and permitted to use it, you still have a responsibility. There are a few stories going around in IR circles of practitioners using generative AI in submissions, being asked to please bring copies of the cases referred to therein, and then having to admit that they can't find them because they don't exist. Specific prohibitions, non-publication orders. So particularly I think in our context, there are often non-publication orders made in teaching and police matters. You can't populate them or put them into any of those kinds of facilities or programs. So please make sure that you're across that. And the other thing that you need to be across is the statement that you need to make in respect of your use of generative AI when you're filing your material as well. So I'm just going to, I've already spoken to the professional responsibility and disclosure as well. I guess the only other point I'd make is that this is obviously a space which is evolving very quickly. And so as the practice note itself anticipates, this will be reviewed regularly as the technology evolves and our use progresses and we learn as well. So on to the next slide. So we're just about to finish up. The only other thing I wanted to say was that the workplace relations community is one that I've been a part of for my whole career, and it's awesome. I know many of you in this room, so get involved, and I am on the committee of the Industrial Relations Society of New South Wales who supported this event, and I encourage everyone to connect. It's a great place to meet people on all different sides of the fence and to learn new things as well. Moving on to the next slide, and I hope advocacy in particular and the types of matters that we deal with time to time can be quite tough. So if you're not having fun and you're unsure, it's a great idea to be able to kind of reach out to your colleagues, hence joining the IR Society and connecting with other people. And when you've felt like you've learned enough, then offering that up to other people as well. Because finally, I don't know about any of you, but sometimes I need to think back and remember why I became a lawyer at all. And for me, well, you know, it was a few good men. For some of us, it might have been LA Law. For some of you, it might have been Ally McBeal, and some of the younger people in the audience, maybe Rake or Suits or Legally Blonde. So it is meant to be fun, and you know, I hope that you're able to carry that through and you enjoy coming to the Commission as we enjoy having all of you appear before us as well. And with that, any questions?
Thanks, Janine. I can say that for our ABL participants, there is a facility for questions if you use your chat function, I'm told, on WebEx, and we'll try and get to you if, although I think we'll probably give some priority to those who have attended in person. So please feel free to ask any questions. The question is, what is the Commission's attitude to when a union is representing an individual in proceedings, whether or not the individual ought to be present with the union representative at those proceedings?
Usually they should be, particularly where, you know, it's all fact and degree, but I've had plenty of conciliations where everything is about that individual and their circumstances. That is what this matter is about, and in my view, that person should absolutely be in the room, virtually or otherwise, experiencing and understanding what's going on. You know, there might be an exception. For example, you know, if it's just a mention or timetabling, but usually they need to be there. Yep, absolutely. And the only other, I guess, exception to that I can think of was the matter that I referred to a bit earlier, where you have a union who's representing 50 people. Obviously, that's not practical, and a different process has to be adopted. But most of our matters don't look like that. A lot of them are individual or just a small number of people. So whoever's at the centre of the dispute, and by the way, that applies the other side as well, the decision maker, the manager, whoever that person is who's at the centre of the dispute for the employer, they need to be there as well.
Okay, the question is, what's the best or most expedient way to seek a variation of directions before it's contravened? And that would be, get the consent of your opponent, write and apply to the judge's associate for the directions to be varied by consent, or to the registry directed identifying the commissioners whose directions are about to be breached, and to seek that. That would be the most expedient way. Yeah, and when you're writing, it's a good point Commissioner Webster raises, propose the orders that you want. So draft the orders. Make our lives easier. That is part of the art of persuasion. It doesn't mean to say that we will always make the orders in the form that you propose, but that's a good idea. General pointers about cross-examination. That's a large topic, beyond the scope of our little seminar today. In 20 seconds, stick to the issues. Ask relevant questions, questions that you need to establish your case. It's not a roaming attack on credit or credibility. I mean, that may be a part of your legitimate forensic purpose in cross-examination, but you're not there to simply attack and criticise at large. You're there to elicit evidence in support of a submission you ultimately want to make. So every question ought to be directed mindfully to why you're asking it in the service of what submission you are ultimately going to make. Now, how you do that, there's lots of different styles and techniques, but if there's one thing I could say about it, that would be it, I think.